Hello, welcome everyone. We are here with another session on criminal law और आज हम थोड़े से क्वेश्चंस क्रिमिनल लॉ के ऊपर सॉल्व करने वाले हैं और फटाफट से मुझे बता दो, एम आई परफेक्टली विजिबल एंड ऑडिबल टू ऑल? जल्दी से मुझे थम्स अप दे दो एंड देन वील स्टार्ट द सेशन. आज का सेशन वुड बी ऑन क्रिमिनल लॉ. ठीक है, तो फर्स्ट क्वेश्चन दैट वी आर गोइंग टू सॉल्व, ये क्वेश्चन 2021 या 2020 क्लैट से पूछा गया था क्लैट में. एंड दिस इज ऑन मेजरली ऑन इंडियन पिनल कोड 494 जो सेक्शन हुआ करता था हमारे पास पहले. अब तो इट हैज बीन चेंज्ड, द नंबर वुड आल्सो हैव बीन चेंज्ड. इट वाज ऑल अबाउट the alimony and the maintenance of what is going to happen. So yes, the question is on the same. So marriage is necessarily basis of social organization. We'll read the question, then we'll go to the factual questions जो हमारे पास हैं, and then you guys are going to answer it. So बेसिकली जब भी हम लीगल के क्वेश्चन सॉल्व करते हैं, कुछ टिप्स एंड ट्रिक्स जो मैंने हमेशा बताई हैं कि आपको पता होनी चाहिए. ओके, थैंक यू फॉर द कंफर्मेशन कार्तिकेय. ओके, सो कुछ टिप्स एंड ट्रिक्स जब भी हम कोई भी लीगल क्वेश्चन सॉल्व करते हैं वो ये होती हैं कि आप थोड़ा सा पैसेज को पहले देख लो कि किसके ऊपर एक्चुअली पैसेज है. ठीक है, फर्स्ट थिंग इज दैट. सेकेंड थिंग इज दैट कि आप क्वेश्चंस देखो कि क्वेश्चंस फैक्ट स्पेस में क्या क्या क्वेश्चन पूछे गए हैं. ऊपर से एक बार प्राइमा फेसी जस्ट सुपरफिशियली आप ऊपर से देख लीजिए सारे क्वेश्चन. सबसे पहले आप फैक्ट्स के क्वेश्चंस को पढ़िए, उसके बाद आप पैसेज पे जाइए. दिस इज द मेन टेक्निक जो हमेशा बोली जाती है टू यूज. बट देन हम अभी क्वेश्चन को देखेंगे, पैसेज को देखेंगे एंड विल फिगर इट आउट कि हम कुछ अंडरलाइन भी कर पाए कि हमको क्या क्या चीजें इंपॉर्टेंट लगती हैं. तो आप ये भी कर सकते हो. प्लस अगर आप बहुत अच्छे हो स्पीडिंग में, रीडिंग स्पीड में, तो यू कैन जस्ट अंडरलाइन फ्यू ऑफ द फैक्ट्स एंड देन गो अहेड एंड स्टार्ट सॉल्विंग क्वेश्चंस. हर बच्चे के लिए टिप्स एंड ट्रिक्स थोड़ी अलग होती हैं, थोड़ी डिफरेंट होती हैं, बट देन ओवरऑल कहीं ना कहीं this is how you solve the questions. The first question is, marriage is necessarily the basis of social organization and the foundation of important legal rights and obligations. So they are talking about marriage, which is institution of marriage के बारे में बात कर रहे हैं. The importance and imperative character of the institution of marriage needs no comment. In Hindu law, marriage is treated as a samskara or a sacrament. The Hindu Marriage Act 1955 introduced monogamy as a law of marriage among Hindus by virtue of Section 5, Clause 1, which is essentially the voluntary union for life of one man with one woman to the exclusion of all others. It enacts neither party must have a spouse living at the time of marriage. The expression spouse, spouse here used means a lawfully married husband or wife. Before a valid marriage can be solemnized, both parties to such marriage must be either single or divorced or a widow or a widower, and only then they are competent to enter into a valid marriage. They're talking about what is a valid marriage, what is a monogamy. They are talking about how important the marriage is with respect to the Hindu Marriage Act and with respect to the society as a whole. If at the time of performance of the marriage rites and ceremonies, one or the other parties had a spouse living and the earlier marriage had not already been set aside, the later marriage is no marriage at all. So they're talking about what would be a valid marriage and what would not be a valid marriage. उन्होंने कुछ pointers दे दिए जो valid marriage को बताते हैं, कुछ pointers दे दिए जो invalid marriage को बता रहे हैं. The Supreme Court in Bhaurao Shankar Lokhande versus State of Maharashtra prima facie held prima facie the expression whoever marries in section 494 of the Indian Penal Code 1860, which defines offense of bigamy, must mean whoever marries validly or whoever marries and whose marriage is a valid one. If marriage is not valid according to the law applicable to the parties, no question arises of its being void by reason of its taking place during the life of the husband or wife of the person married. One of the conditions of a valid marriage under the Hindu Marriage Act 1955 is that it must be solemnized. Further, Section 13(2) of the Act provides for grounds of divorce to wife and states. A wife may also present a petition for the dissolution of marriage by a decree of divorce on the ground that in the case of any marriage solemnized before the commencement of this act, that the husband had married again before such commencement, or that any other wife of a husband married before such commencements was alive at the time of the solemnized the marriage of the petitioner, provided that in either case the other wife is alive at the time of the presentation of the petition. Basically, they were talking about what valid marriage is, what invalid marriage is, what are the grounds on which there would be invalid marriage, and also how a wife is gonna get go for the dissolution of marriage. This is what they are talking about. So the first question: Mr. A 40-year-old male Hindu, was married to Miss B, a 36-year-old female Hindu. Mr. A fell in love with his colleague, Mrs. C, a 22-year-old female Christian. On April 8, 2020, Mr. A declared Mr. C as his wife in front of his colleagues, family members, and relatives. Based on the given facts, decide the liability of Mr. A as per the Hindu law. Mr. A is not liable for the offense of bigamy as Mrs. C is a Christian. Mr. A is liable for the offense of bigamy as mere declaration also amounts to solemnization. Mr. A is not liable for the offense of bigamy as he has not solemnized his marriage with Miss C. Mr. A is liable for the offense of bigamy as there was no intention to marry. Give me the answer. Kartikeya is saying one is C. Chandralekha is saying one C. Both of them are saying C. So when we see the paragraph, what is it is saying about the solemnization? The expression spouse here means a lawfully married husband or wife. Before a valid marriage can be solemnized, both the parties to such marriage must be either single or divorced, or a widow or a widower, and only then they are competent to enter into a valid marriage. Right? Here, he wasn't divorced, he was single, and he wasn't single. He was neither a widow, he was not either a widower as well. So the marriage cannot be actually solemnized, right? So what would be the answer? Mr. A is not liable for the offense of bigamy as he has not solemnized his marriage with Miss C. Mere declaration won't be happening. Which of the following statements correctly expresses the interpretation of the word solemnize under Hindu law? Solemnization means celebrating the marriage with proper customary rites and ceremonies of either party to a marriage. Solemnization includes and means promising each other a lifetime of happiness. Solemnization is not necessary in modern marriages when registration of marriage is complete. Solemnization is a mere formal practice and not a mandate. Yeah, we'll come to your question, Riva. It's not the case of bigamy. It's the case of mere Chandralekha is asking whether the answer is 2A. What would be the answer? It would be adultery. It won't be desertion. And adultery is also one of the facts when you can go ahead and ask for a divorce. Okay, so which of the following statements correctly expresses the interpretation of the word solemnize under Hindu law? The answer would be A. Solemnization means celebrating the marriage with proper customary rites and ceremonies of either party to a marriage, which is the word meaning very easy on the fact of it. Which of the following is not correct regarding the law of monogamy among Hindus? Monogamy is a union of a man and a woman which provides their relation a social and legal recognition. Monogamy as a law was abolished after 1955. The second marriage during the subsistence of first valid marriage is void. If a husband solemnizes a second marriage during the subsistence of first marriage, it is not an offense. However, it is an offense if a wife commits the same act. Which one is not the correct answer? Yes, it is because she he found that his wife was cheating on him. How it could be D? Shouldn't it be monogamy as a law was abolished after 1955? It was made valid with the respect to 1955 Act. How it could be D? I think it will have multiple answers. The Hindu Marriage Act introduced monogamy as a law of marriage among Hindus by virtue of Section 5 Clause 1. The other, we can see which would be the more closer answer to what जो हमारे passage से थोड़ा सा ज़्यादा relate करेगा. तो monogamy is a union of a man and a woman which provides social and legal recognition. This is a correct statement. B is not a correct statement. The second marriage during the subsistence of first valid marriage is void, which is also a correct statement. The D is if a husband solemnizes a second marriage during the subsistence of the first marriage, it is not an offense. However, it is an offense if a wife commits the same act. I think D is also wrong. D is also wrong and B is also wrong. Here, both of the options are wrong. So we can mark either B or D. I think वो एक तो होगा ही. They should have given the options of, and this is a question का paper, मतलब CLAT का paper. तो you never know. Options उन्होंने थोड़े ऊपर नीचे किए. On the basis of Section 13 of the Hindu Marriage Act 1955, which of the following statements does not relate to the remedy? The object of the section was to provide an opportunity to the wife in the form of remedy of divorce. The introduction of this ground of divorce is unnecessary as it disturbs the sanctity of marital institution. A remedy is only available under this section if the husband has a other wife living. The living status of either spouse is immaterial to claim the remedy. What was the object of section 13.2? It was for the grounds of divorce to wife. तो यहाँ पे कौन सा वाला सही होगा? The objection of the section was to provide an opportunity to the wife in the form of remedy of a divorce, right? Would it be A? Or would it be D? The living status of either spouse is immaterial to claim the remedy. Which would be the closer answer? Let's read it again. A wife may also present a petition for the dissolution of a marriage by a decree of divorce on the ground that in the case of any marriage solemnized before the commencement of this act, that the husband had married again before such commencement, or that any other wife of the husband married before such commencement was alive at the time of the solemnization of the marriage of the petitioner. Provided that in either case the other wife is alive at the time of the presentation of the petition. What should be done? What would be the correct answer? A or D? Pakka D. जल्दी बताओ जल्दी बताओ जल्दी बताओ. Oh, right, it says it does not relate to the remedy, right? So the answer would be D. Then our answer would be D. Correct. I did not read does not. My bad. Okay, moving on. The last question. Mr. P, a 28-year-old male Hindu, was legally married to Miss Q, a 26-year-old female Hindu. Mr. P converts to Islam to marry Miss N, a 30-year-old Sunni female Muslim. Consider the statement and decide whether Miss Q has the remedy to file a complaint for the offense of bigamy against Mr. P. Answer. Yes, Miss Q can file a complaint subject to the approval by Miss N. No, Miss Q cannot file a complaint and it defeats the very purpose of the marriage with Mr. P. No, Miss Q cannot file a complaint as Mr. P converted to another religion. The offense of bigamy will only be attracted when the parties are Hindus. Yes, Miss Q has the remedy of filing a complaint for the offense of bigamy. What happened? Okay, yeah. Miss Q has all the rights to file a complaint. So yes, Miss Q has the remedy of filing a complaint for the offense of bigamy. This is the right answer. Because they both were Hindus, plus they got married earlier, and then he converted into Islam and getting married to another person. So that is wrong. Just to get married, they are converting their religion. This has happened with a lot of celebrities as well. Though, so earlier what they used to do was used to go to Goa and actually do the marriages because वहाँ पे uniform civil code चलता है. वहाँ पे ऐसे it's not any other code that is valid. So people used to do that, but then that was banned. So the marriages were happening were banned. Next, the Indian Penal Code 1860 does not define consent in positive terms, but what cannot be regarded as consent under the code is explained by Section 90. Section 90 reads as follows: consent known to be given under fear or misconception. A consent is not such a consent as is intended by any section of this code. If the consent is given by a person under fear of injury or under a misconception of fact, and if the person doing the act knows or has reason to believe that the consent was given in consequence of such fear or misconception, consent given firstly under fear of injury and secondly under a misconception of fact is not consent at all. That is what is enjoyed with the first part of section 90. So क्या क्या consent कंसेंट अगर किसी फियर से ली गई हो और कोई मिसकंसेप्शन से ली गई हो तो it won't be a consent at all. These two grounds specified in section 90 are analogous to coercion and mistake of fact, which are the familiar grounds that can vitiate a transaction under the jurisprudence of a country as well as other countries. The factors set out in the first part of section 90 are from the point of view of the victim. The second part of the section 90 enacts the corresponding provision from the point of view of the accused. It envisaged that the accused too has knowledge Accused who has knowledge or has reason to believe that the consent was given by the victim in consequence of fear or injury or misconception of fact. Thus, the second part lays emphasis on the knowledge or reasonable belief of the person who obtained the tainted consent. The requirements of both the parties should be cumulatively satisfied. In other words, the court has to see whether the person giving the consent had given it under fear of injury or misconception of fact, and the court should also be satisfied that the person doing the act, that is the alleged offender, is consequence of the fact or should have reason to think that but for the fear or misconception, the consent would not have been given in the scheme of section 90, which is couched in negative terminology. Section 90 cannot, however, be construed as an exhaustive definition of consent for the purpose of Indian Penal Code 1860. The normal connotation and concept of consent is not intended to be excluded. Various decisions of the High Court and the Supreme Court have not merely gone by the language of section 90 but traveled a wider field guided by the etymology of the word consent. So the first question is, a man promises B a woman that he will marry her if she has sexual intercourse with him. B agrees, but after having sexual intercourse, A flees and never contacts B again. In the given situation, which statement is true? Consent for sexual intercourse was given under misconception of fact. For sexual intercourse was given under fear of injury. Consent for sexual intercourse was given under undue influence. Consent for a sexual intercourse was given without any misconception or fear of injury. So there were only two facts that are going to be relevant. Either it would be fear or misconception of fact. What is there? I believe it was a misconception of fact clearly on the face of it. So answer would be A. According to the given passage, a person is said to consent to the doing of an act if a person agrees to do an act without misconception of fact or fear of injury. A person to whom agreement is signified has no reason to believe that an agreement is being given under misconception of fact or fear of injury. A person agrees to do an act without misconception of fact or fear of injury, and the person to whom agreement is signified has no reason to believe that the agreement is being given under misconception of fact or fear of injury. A person agrees to do an act without having regard to the consequence of fear of injury or misconception of fact. Which one would be the closest answer? Yes, Kartike, it would be C because it is the most closest to what our passage is actually telling us. A person agrees to do an act without misconception of fact or fear of injury, and the person to whom agreement is signified has no reason to believe that the agreement is being given under misconception of fact or fear of injury. सो हमारे पैसेज दो तरीके से बात कर रहा था, एक अक्यूज के तरीके से बात करता है, एक विक्टिम के तरीके से बात कर रहा था, ठीक है। और ये जो स्टेटमेंट है वो दोनों तरीके से बात कर रही है। According to your understanding of the given passage, why is negative terminology used to explain the meaning of consent under section 90? To emphasize on the factors that vitiate consent, to emphasize on the point of view of victim or the person who gives consent, to emphasize on the point of view of the person who receives consent, to emphasize on the non-exhaustive scope of definition of consent. Give me the most closest answer. I believe they are talking about only two factors. ठीक है, क्या fear और misconception of fact. तो emphasize on the factors that vitiate consent. ठीक है, तो यहाँ पे आंसर would be A. What is your answer? किसी ने भी आंसर नहीं लिखा थर्ड का अभी तक. Why कार्तिक? Why it would be B? वहां पे सिर्फ विक्टिम की बात हो रही है, वहां पे अक्यूज की बात नहीं हो रही. हमारा पैसेज दोनों तरफ से बात कर रहा है और उसने एम्फेसाइज भी किया है इस चीज को, इसलिए इसका आंसर ये होगा. एक्स अ मैन और नॉन एग्जॉस्टिव भी नहीं है, क्योंकि स्कोप का तो पता. नॉन एग्जॉस्टिव तब होती है जब हम दो पॉइंट से कुछ बोल दे एक्सेट्रा. नॉन एग्जॉस्टिव तब होती, बट ये तो एग्जॉस्टिव है, दो उन्होंने पॉइंट्स दे दिए प्रॉपर, राइट. X, a man promises Y a woman that he will marry her if she has sexual intercourse with him. Y agrees and they have sexual intercourse. Thereafter, X assures Y that they will get married, but X family is opposed to the marriage even after X attempts to convince them. Therefore, X refuses to marry Y. In the given situation, which statement is true? Consent for sexual intercourse was received knowing that the consent is given under misconception of fact. Consent for sexual intercourse was given without any misconception of fact or fear of injury. Consent for sexual intercourse was received knowing that the consent is given under the fear of injury. Consent for sexual intercourse was given under misconception of fact, received misconception of fact. Fear तो कहीं नहीं है इधर पे. There is no fear. तो वो इंफॉर्मेशन ली भी मिसकंसेप्शन ऑफ फैक्ट के ऊपर है और दी भी गई मिसकंसेप्शन ऑफ फैक्ट पे. तो आंसर वुड बी डी हियर. बाकी सब उतने अलाइन नहीं हो रहे. According to the given passage, which of the following statement is not true? Misconception of fact vitiates consent. Fear of injury vitiates consent. Misconception of facts obviates the necessity of consent. Fear of injury is analogous to coercion. The answer is very easy. Fatafat, fatafat. Give me the answer. The answer is C. On the face of it, it's given C. Misconception of facts obviates the necessity of consent. ठीक है. बाकी तीनों के तीनों हमको पैसेज में दिए हुए थे, तो they all are true. The only the C is not. Next passage. Questioning a case of cruelty that was filed against a man by his wife. The Bombay High Court said that if a married lady is asked to do household work for the family, it cannot be said that she is treated like a maidservant. The court was hearing an application by the husband and his parents seeking that proceedings against them are quashed. A FIR was filed against the trio in September 2020, around 9 months after the marriage, alleging that they hounded the woman for money to purchase a car, harassed her mentally and physically, and treated her like a maidservant. Examining the evidence, the court found there was no merit to the woman's allegations. The court said that though the FIR says that she was treated properly for about a month and then like a maidservant, there are no details of what this meant. The court added, if a married lady is asked to do household work for the purpose of the family, it cannot be said that it is like a maidservant. The court held that the mere use of the word harassment mentally and physically in the FIR is not sufficient to constitute an offense. Section 498A of the Indian Penal Code, which punishes the husband or a relative of a husband of a woman who subjects her to cruelty in any way. It is interesting to note that Section 498A of IPC also provides that if a married woman is actually treated like a maidservant, it would be an offense under the section. Okay, this is an extract taken up from Bombay High Court's decision. Now there are questions. Ashwin and Ashima were married in Feb 2020. In March 2020, Ashwin asked Ashima to take care of all their household work, such as cooking, cleaning, and other domestic chores, as he was very busy with his professional responsibilities. Ashima claims that this amounts to treating her like a maidservant and constitutes an offense under Section 498A of the IPC. Applying the Bombay High Court decision, is she likely to succeed? बॉम्बे हाईकोर्ट को जो डिसीजन उन्होंने दिया है पैसेज में वो तो डिनायल में, ठीक है, दे दैट विल से नो नो नो, ठीक है, तो हमारे पास दो ऑप्शंस बचते हैं, इधर बी इधर डी, तो इसमें से कौन सा आंसर होगा? नो सिंस अश्विन हैड ओनली आस्क्ड अश्विन टू डू देयर हाउसहोल्ड वर्क नॉट फॉर अदर्स, या ये वाला नो, नो सिंस ट्रीटिंग अ मैरिड वुमन लाइक अ मेड सर्वेंट वुड नॉट अमाउंट टू ऑफेंस अंडर द सेक्शन. आई थिंक the answer would be B, क्योंकि that most closely relate to the facts that are given. No, since Ashwin had only asked Ashima to do their household work. He is not asking कि आप दूसरों का भी काम करो. He is only asking कि हमारा काम करो. ठीक है. In April 2020, according to Bombay High Court's decision, जो उस वक्त आया होगा, ठीक है. In April 2020, Ashwin's friend Rakesh visits Ashwin and Ashima's home and stays with them for a few days. During his visit, he is very mean to Ashima and uses abusive language with her. He also threw a plate at her one evening when he was unhappy with the meal that she had prepared. Ashima now claims that Rakesh has committed offense under Section 498A of the IPC. Is she likely to succeed? Now tell me, is she likely to succeed under cruelty? इसमें दो ऑप्शन अगेन नो है, दोनों नो हटा दो. इट वुड बी यस, क्योंकि यहाँ पे उन्होंने बोल दिया अब्यूसिव लैंग्वेज यूज हो रही है, उसके ऊपर प्लेट भी थ्रो करी है, तो दैट इज हर्ट आल्सो, राइट? नाउ व्हिच yes would be the feasible one? Yes, since Rakesh's use of abusive language and throwing the plate at Ashima clearly amount to cruelty. That is correct. D option भी देखते हैं. Yes, since Rakesh was staying at Ashwin and Ashima's home at the time of the incident. No, that is irrelevant. So what would be relevant answer? B would be relevant answer. Frustrated and upset with her marriage, Ashima applies for and is granted a divorce from Ashwin in November 2020. Since she and Ashwin had been friends for many years before they got married, she stays in touch with him. She moves into her own apartment, and starts going to office regularly at a new job. Ashwin is very upset at this and starts treating Ashima very cruelly. Ashima again claims that Ashwin has committed an offense under Section 498A for the IPC. Is she right? Now he is committing what? Now he is very cruel towards Ashima. Correct? Cruelty is being committed. So it would be yes. Yes, since Ashwin has, as we are told, treated her cruelty. Yes, since Ashwin has been her husband. No, since Ashwin was understandably upset at Ashima's behavior. No, since she is no longer married to Ashwin. Is she married to him or not? Now is she still married to him or not? तो ऑफेंस 498A के अंडर तो नहीं लग सकता, दूसरी चीजों के अंडर लग सकता है. ठीक है, तो जो सेक्शन है दैट इज इनअप्रोप्रिएट. दूसरा हम लगा सकते हैं कि भाई कोई हमको क्रुएलिटी की तरह ट्रीट कर रहा है, कोई हमको अब्यूज कर रहा है, या दैट पर्सन इज नॉट ट्रीटिंग एज वेल विथ रिस्पेक्ट टू वेरियस विसिनिटीज जहां जहां पे वो ट्रीट नहीं कर रहा है, जैसे भी नहीं कर रहा है. डेफेमेशन का केस लगा सकते हैं, या कुछ और मेंटल टॉर्चर का भी केस लगा सकते. तो एनी अदर थिंग दैट वी कैन गो एंड अप्लाई, बट नॉट अंडर 498A बिकॉज दे आर ऑलरेडी डिवोर्स्ड, दे आर नॉट मैरिड नाउ. Assume that the government passes, the answer would be D. No, since she is no longer married to Ashwin. Assume that the government passes a new law in January 2021 called the Protection of Rights of Married Women Act 2021, according to which asking a married woman to take care of household chores would be an offense. The act also provides that if a man commits such an offense, he would have to pay compensation to the woman. The act even applies to actions that were committed any time in the 3 years prior to the new law coming into force. Retrospective effect भी था इसका, 3 साल पहले का भी था. And even if the man and woman involved in the matter were no longer married, मतलब अगर वो अब नहीं married हैं और पहले उनके साथ cruelty हुई है, तो that was also valid. Upon hearing about this new law, Ashima once again alleges that Ashwin has committed an offense under Section 498A of the IPC and claims compensation under the Act for his action. Is she right, and will she be succeeding? देखो 498 के अगेन मैं तो वो स्टिल नहीं जा सकती क्योंकि दे आर नॉट मैरिड. 498 की फर्स्ट चीज ही थी कि दे शुड बी मैरिड. ठीक है, तो दे आर डिवोर्स्ड. हाँ, उस एक्ट के अंडर कॉम्पनसेशन जरूर ले सकती है. क्यों? क्योंकि वो रेट्रोस्पेक्टिवली बिहेव कर रहा है, तो कॉम्पनसेशन आप मांग सकते हो, बट शी इज नॉट राइट हियर. तो आंसर वुड बी Ashima is right about Ashwin's committing an offense? No. Yes, but she will not get the compensation. She will get the compensation. Ashima will get compensation under that. Yes, but she's not right about Ashwin committing an offense under that is the correct option. Let's see other options as well. Ashima will get compensation under the act, and she's also right. No, she's not right. Ashima will neither get compensation nor she's right for Ashwin. So answer would be B. Right? Next question. Assume that in March 2021, the government changes Section 498A of the IPC. The effect of this change is that asking a married woman to do household chores, even for their own family by herself, would be considered cruelty and therefore an offense under the section. Some days late, after this change comes into effect, Shamita, Ashima's friend at work, tells her that her husband has been forcing her to do all the household work by herself. Ashima tells Shamita that her husband's action would amount to an offense under the section, even though Ashima herself has been unsuccessful in having Ashwin's convicted under the section in the past. In Ashima's advice to Shamita, correct. अब तो कोर्ट ने रूलिंग दे दी है, तो सही तो होना चाहिए. Yes, since section 498A has now been changed and Shamita's husband action would now be offense. No तो होगा नहीं, क्योंकि अब तो कोर्ट ने बोल दिया है कि भाई now this is legal. जो जो उन्होंने बोला था कि नहीं 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 that is not going to be legal. अगर कोई भी वुमेन है वो अपना हाउस होल्ड कोर्स कर रही है विद रिस्पेक्ट टू द सेम, इट्स नॉट गोइंग टू बी क्रुएलिटी, बट नाउ दे हैव सेड इट वुड बी अ क्रुएलिटी. नो तो दोनों बी और डी तो ऑप्शन हटा दिए. ए और सी देखते हैं. ए तो अपने पढ़ लिया, सी देखते हैं. यस, सिंस द पासिंग ऑफ द प्रोटेक्शन ऑफ मैरिड वुमेन एक्ट हैज रिजल्टेड इन शमिता's husband's action being made illegal. No, the answer would be A, because now the 498A has been changed. Act थोड़ा ना चेंज हुआ, 498A चेंज हुआ. Next, the Indian legal system places a significant emphasis on protecting the rights and welfare of children. The JJ Act is a vital piece of legislation in this regard. It is designed to ensure that children in conflict with the laws receive special care, protection, and treatment, with the ultimate goal of their rehabilitation and reintegration into society. One of the key provisions of the Act is establishment of JJ boards at the district level. These boards consist of the Metropolitan Magistrate or Judicial Magistrate first class and 2 social workers, at least one of whom would be a woman. The primary function of the JJB is to determine the age of the juvenile, the circumstance in which the offense was committed, and whether the juvenile should be sent to the special home or released on probation. The Act makes a clear distinction between a child in conflict with the law and child in need and care of protection. A child in conflict with law is one who has committed an offense, while a child in need of care and protection is a child who is vulnerable or at a risk and requires special care and support. The Act introduces a unique approach to dealing with children who are in conflict with the law. For children between the ages of 16 and 18 who have committed heinous offenses, they can be tried as adults subject to the preliminary assessment by the Juvenile Justice Board. This assessment considers the child's mental and physical capacity to commit such an offense. If the board determines that the child should be tried as an adult, the case is transferred to the regular criminal courts. The Act also places restrictions on the publication of information that could lead to the identification of the juvenile offender. This is done to protect the privacy and future prospects of the child. समझ आया पैसेज? सिंपल पैसेज है, कुछ इसमें ऐसा डिफिकल्ट नहीं है, सेल्फ एक्सप्लेनेटरी है कि जेजे एक्ट क्या होता है, जेजे बोर्ड क्या होता है, उसमें कौन कौन से जजेस होंगे, क्या क्या होगा, किसको कॉन्फ्लिक्ट ऑफ लॉ बोलेंगे, चाइल्ड को किसको केयर एंड प्रोटेक्शन के लिए भेजेंगे, एवरीथिंग इज रिटन देयर. What is the primary objective of the JJ Act? To punish child offenders, to rehabilitate and reintegrate children in conflict with the law, to remove all forms of violence against children, to increase the age of criminal responsibility. Chandrelekha is saying B. Okay. Okay. Other students? क्या क्या सिग्निफिकेंस था जेजे एक्ट का? The ultimate goal of the rehabilitation and reintegration into society. The answer would be B, right? Who makes up the Juvenile Justice Board? 2 judges, MM and 2 lawyers, MM or JMFC and 2 social workers. The answer is C. हमने clearly देखा था, एक MM होना चाहिए, Metropolitan Magistrate होना चाहिए, JMFC होना चाहिए, Judicial Magistrate first class होने चाहिए, and 2 social workers. What is the role of JJ Board? To determine the punishment for juvenile offenders, to decide whether a child should be sent to a regular prison, to assess the age and circumstance of the juvenile and make a decision on rehabilitation, to prosecute child offender. क्या था हमारा? JJ Board जब फॉर्म हुआ, मेट्रोपॉलिटन to primary function of the JJB determine the age of the juvenile, the circumstances in which the offenses was committed, and whether the juvenile should be sent to the special home or released on probation. ठीक है? What is the role? Yes, the answer would be C, to assess the age and circumstance of the juvenile and make decision on rehabilitation. What is the distinction between a child in conflict of law and child in need and protection of the care? There is no distinction. Both the terms are same, which is wrong. A, child in conflict with the law has committed a crime, and B, the child in care and protection is vulnerable or at risk. The answer is B. We will not see other options. Under what circumstance can children between the ages of 16 and 18 be tried as adults? They can always be tried as adults after a preliminary assessment of the JJ board when they have committed any offense regardless of the severity when they reach the age of 18. When they reach the age of 18, पहले हमारा जेजे बोर्ड डिसाइड करता है कि वेदर उसकी कैपेसिटी उतनी थी या नहीं थी, क्या वो 18 इयर्स का या 17 इयर्स का, 17.5 इयर्स का होके भी ही डिड नॉट हैव दैट मच ऑफ कैपेसिटी ऑफ थिंकिंग कि भाई मैं वो एक्ट कमिट करता और वो एक्चुअली क्या होता, इट वुड हैव बीन अ ऑफेंस. So answer would be B, after preliminary assessment with the JJ board. What is the purpose of placing restrictions on the publication of information related to juvenile offenders? Yes, it is to protect the privacy and future prospects of the child, which is really necessary. अगर कोई भी juvenile कोई भी act commit करता है which is bad, हम उसकी जो भी real नाम और ये सब कुछ होता है, we usually hide it because we don't want कि उसको future में कोई भी दिक्कत आए, right? That is end of it, and we have started the CLAT sprint batch. It is also started in English as well. Go and check it out on LST website. See and check it out कि जो बच्चे अभी भी सोच रहे हैं कि हमको CLAT लिखना चाहिए within the 4 months, ये उनके लिए बैच बहुत अच्छा बैच है. Go and find it out. It is there on LST channel, LST website. Go and see it. Online it's available. Okay. And और बाकी से डिटेल्स आपको पेज पे मिल जाएंगे. So that is it. Thank you so much for the session, guys. I'm really happy that you all are here. Thank you so much. Bye bye. Take care.